is Kiati. I'm head of Joshi Advocates. Thank you very much for joining us in this video. Spouse visas applications submitted in the lockdown in the UK, but they were refused, and the appeals have been successful. And here is the story time. So we have consent from Jennifer, whose appeal has been allowed by Judge Dixon in Birmingham First Tier Tribunal. So here it goes. Jennifer was married to Richard, and she's from Botswana. She could not leave the UK during the COVID-19 time. You know, it's lockdown. And she also had a friend. Remember Jane? Jane from our previous video, who in the same situation made her application and she was given the 5-year spouse visa route. Jane and Jennifer are friends. So anyway, they made the application at the same time. Jane's allowed. Home Office gave her the 2.5 on the 5-year route to spouse settlement, but they refused Jennifer. They made the application same time, same situation. So then Home Office said no, Jennifer could leave the UK. It's no longer lockdown. It was lockdown when she applied. So at court, lucky Jane appears as one of the witnesses to tell the judge, no, I applied the same time as Jennifer. I have the same situation as Jennifer. I was given, here's my biometric card. The Home Office didn't question Jane. They more or less accepted that, yeah, she's given it. And the judge is like, oh, is that the only question you have? I think the Home Office asked one question. When did you make your application? Same time as Jennifer. And then Jennifer gives evidence, explains that she did overstay her leave visit visa, and she made the application in lockdown because she could not leave to make the same application for entry clearance. And Home Office accepts that Jennifer met all the requirements. Now, the judge asked the husband sponsor, why don't you leave the UK with her, or why don't you let her go to make the application? And he explains his situation, that he had suffered from cancer, although it's, everything's okay now. But, that being with Jennifer has given him hope to be stronger. And at that point, the judge said, why don't you become a bit more stronger and let her go so she may come back with the correct visa, having followed the correct process. And he says, well, we made the application same like Jane. How come Jane's allowed and not my wife? And what guarantee is it that this COVID-19 thing is going to go away and my wife Jennifer, will come in the UK? And I'm going to come back to this, but look, now there's this Omicron. So maybe he's right, there is no guarantee. Anyway, the Home Office says no, Jennifer could leave the UK and apply for entry clearance. And the judge says, look, she's met all the requirements you accept. The only glitch here is that she's making it whilst in the UK. And how come the Home Office has given Jane the visa in the same situation and not Jennifer? Why is the Jennifer not given the visa on the COVID-19 guidance? Because Home Office saying the COVID-19 guidance doesn't apply to those overstayers. But then the judge has Jane, who is an overstayer and who has been given in the same situation the 5-year spouse route, 2.5 leave to remain. So lo and behold, it was Jennifer's birthday on the day of the hearing, and she got an amazing present. The judge on the day, this is very rare, but on the day the judge said he would allow the appeal. The appeal has been allowed. I have consent to give you the decision for your benefit. So if you are appealing and you are in the same situation as Jennifer, an overstayer in the UK, made the spouse visa application in the UK because of lockdown, and the appeal hearing is pending, put this decision in your bundle to show the judge, to persuade the judge that, look, another judge in the same situation has rationally, practically considered the situation around COVID-19 and spouse visas applications made by overstayers, and has allowed the appeal. Now, the Home Office would say, oh, the judge should not use that decision as binding. That's fair. No one is saying Jennifer's decision, as you will have very soon in the description box below, is binding in the judge in your appeal or any other judge. It's not binding. All it is showing the judge in your appeal that another judge has rationally, practically considered the circumstances around COVID-19 guidance, the Coronavirus Regulations 2020 Schedule 5, Aguiar, Chikwamba, all these cases and all this law, and practically determined that it would be reasonable to grant and allow the appeal. So amazing Christmas present now to you that you have this case law to strengthen your appeal and win it. Now, fingers crossed you are successful. As always, contact details below, subscribe, and I'll see you next week. Thank you so much. Take care.